Welcome back. We're on the home straight now. We've just got this final section on the Data Protection Act. And this is probably worth maybe 1 mark in your exam, so not massive, but it's quite interesting anyway. So the Data Protection Act was introduced as a result of EC law, and it's about protecting all that information that is held about you on various databases up and down the country. And we know that one way or another, our information always finds its way onto these databases. And we know that because we seem to get marketing emails and letters from absolutely nowhere, from people we've never heard of before. Now, the Act sets out 8 key principles which anyone who handles personal data has to follow. Now, personal data is defined as any data from which the individual can be identified without any other information. So if that information was perhaps codified and there was another piece of information somewhere that, when you put the two together, you can identify a person, that would probably be okay. That's research information, things like that. But anything else will be caught. Now, 2 key terms there. Data controllers are the people who hold the information. Data subjects are the people on whom that information is held. And note, data subjects there does not include companies. We're talking just individuals. So first intuition could be a data controller if we hold information that you've given on your booking forms, but we would not be a data subject. An individual, however, could potentially be both, couldn't they? They could be a data controller and also a data subject. Now, the Act applies to personal data that's held on computers or manual files. And it extends, it's quite wide. It covers not just sort of facts that have been captured about you, but also statements of opinion, statements of intention. We'd like to offer this person a job. We might promote this person. It's all there within that definition of personal data. And the Act is meant to cover the whole process of holding data, from the collection, the use of it, who you give it to, who you disclose it to, and finally the destruction of the data. Now, if you don't comply with the Data Protection Act, the penalties can be quite draconian. You can be civilly liable to damages if the data subject sues you, but to do so, they must show that they have suffered some loss. So they're not liable just because they've breached the Act, they're liable if the individual has suffered harm. So they must show that the individual suffered loss. There is potentially criminal sanctions, and these are normally enforced by way of a fine, although there is scope there for someone to be imprisoned if it's a serious breach of the Act. The courts can take action. They can order that the database be corrected, that it be destroyed, that it be forfeited. Any of those is possible. And finally, the Information Commissioner can impose a fairly massive fine, up to £500,000, £500,000. And I think that was invoked quite recently of an NHS trust who had a number of laptops that were going to be disposed of. So they sold them to a company, and the terms of the sale were that the company could have the laptops free of charge if they disposed of the confidential data effectively, so that it could never go into the public domain. Unfortunately, they didn't do that. They literally just sold the machines on, and members of the public reported buying computers that held people's personal medical information. So as a result, the National Trust, trust was liable and had to pay huge damages for that, even though they had, paperwork to show that they had actually tried to ensure that the data was properly disposed of. Now, the person who invokes the Data Protection Act, who supervises it, is the Information Commissioner, and he keeps a register of all the data controllers in the UK, and you can ask to see that if you want to. Now, anybody that holds personal data has a legal obligation to register on that register, and you just do it online. And that register, once you've done it, you pay a fee, and then each year you're asked to pay another fee and to update your data. Now, the 8 principles. Now, these could easily be tested, so if you can learn these, do so. First of all, lawful processing and lawful purpose. Your data should be collected fairly and lawfully and should be processed in such a manner. Now, that means that your data can only be collected for and used for the purpose that you have given. So if you give someone data, and this happens frequently on websites, if you give someone data to allow you to order particular goods, If they then sell that data on to use it for other marketing purposes without your permission, then they would be breaching this principle. Also, the information that you collect should be relevant and not excessive. How many times have you gone onto a website and found that the information they want from you goes as far as, your great granny's birth date and things like that? So companies are not allowed to do that. They should only ask for the information that is necessary for the purpose of that order. Has to be accurate. Now, even if that mistake isn't causing you any particular harm, they will still be in breach of that principle if they don't make sure that the information they hold is accurate and up to date. Length of time. You're not allowed to hold that information for longer than is necessary. So imagine we've collected your information on your booking forms to enable us to track you through your qualification, make sure you're taking the right exams at the right time, and to make sure we can contact you if there's any problems with your booking. Once you've finished your qualification, we have no purpose to hold that information and we should dispose of it. The rights is just referring to the fact that data holders should comply with the requirements of the Act. Technical and organisational measures. This is talking about firms having to make sure that they protect the data that they hold. They've got suitable firewalls, they've got suitable password protection, things like that. They don't leave your data on trains, for instance. And then finally, just a point, transfer outside Europe. A lot of companies now might actually operate in the UK, but they might actually have their back office operations outside of the UK. Well, that doesn't excuse them from the scope of the Act. If they do that, and they transfer data outside of the European Economic Area, they must ensure that that information has the same level of protection and security that it would have had within the UK, i.e. that the data holders outside the UK comply with the requirements of the Act. So, those are the 8 principles. What are the rights of the data subjects? We have a right to access the information, to see it. So you can get a copy of that information, even pictures or evidence, and if it's held in some sort of coded format, you need a right to see it decoded. A right to avoid damage. So, if they're processing the data in a way which is damaging you, for instance, maybe credit reference agencies, you have a right to get that stopped. A right to avoid junk mail. Yeah, you might have noticed that. It's amazing, isn't it? Because I always think I tick the box to say that I don't want my information used for marketing purposes, and yet I get so much junk mail. Why? Sometimes I think it's because firms are very clever when they word that question. Sometimes you're ticking to say you will receive other information. Sometimes you're ticking to say you don't want to receive it. Read that box carefully, because if you do then get information, they are in breach of the Act. Automatic decisions. This is really talking again about things like credit scoring and things like that. So if there is a decision that it says there materially affects you, so something that is actually important, shouldn't be based just on automatic processes. Again, insurance applications could be another one there. Compensation if they cause you damage, but again, you must show loss. To take action to correct data, so if you tell them it's wrong, you should be able to enforce that and force them to correct it. And finally, you do have, as a sort of last port of call, the right to go to the Information Commissioner and ask him to check whether the Act has been breached. Now, this is probably the most common area for exams, things which are exempt from the Act. Payroll. You can't ask to see payroll, even your own payroll data, but particularly not other people's. You can't go fishing to see whether someone's been paid more than you. You don't have a right to see your examination script. So if you think the ACA have marked your exam script inaccurately, you don't have a right to insist that you can get that copy of that and get it remarked. Unincorporated members clubs. Again, slightly odd, but you don't have a right to see that. And domestic data, you wouldn't really want to, would you? But, household spreadsheets, collecting shopping bills, things like that, you don't have a right to see that. Research, but only if it doesn't identify you as a data subject and it's being used just for the purpose for which it was gathered. Crime prevention data related to national security, you'd expect that really, wouldn't you? And also confidential references, you don't have a right to see those. So, our final question together. Have a look at Kylie, see what you think the answer should be, and then we'll look at the answer together. Okay, that's my answer. So, does it match yours? So, Kylie, she's a data subject. We don't have to worry about that then. She wants to see information held about her by the company on its personnel files. She's realised it's inaccurate. It hasn't been updated. She's remarried and changed her name. She's also cross that the company won't let her see the payroll records as she thinks she's being paid less than a colleague. Well, does the company face a potential criminal liability for maintaining inaccurate data? Well, yes, potentially. It's unlikely they would get a penalty for that. Is the company bound to pay her compensation? Well, no, they're not bound to. She'd have to show some sort of loss, and it's unlikely she's suffered any loss in this situation. Can she demand access to the company's payroll records? Absolutely not. That's exempt from the Act. Can she demand that the company correct the data? Well, yes, she can. That's one of her rights as a data subject. Okay, so that is it for Chapter 11, and that brings us to the end of our lectures. Now, what you need to do next is to practice as many questions as you can. You have a lot of questions. You have the questions in the study manual and also some of the online questions. Once you're confident with all those, contact your lecturer, your local provider, and ask them if you can have a copy of the mock exam and have a go at that as well. Once you've done all that, you should be ready to take the real exam. As soon as you're ready to take the real exam, contact your local college and ask them to book you in. I wish you the best of luck, and do remember that you can always contact your tutor if you need any help.